The Nationals are working on a secret plan to parachute Fiona Nash back into the Senate seat she was forced to vacate by the High Court. Ms. Nash, the former deputy leader of the Federal Nationals, was disqualified under Section 44(I) of the Constitution, and her place was set to be filled by Liberal Hollie Hughes, who was the next person on the joint coalition Senate ticket. But Ms. Hughes faces constitutional issues of her own, as she was recently appointed to the Administrative Appeals Tribunal by the Turnbull government, which could disqualify her under Section 44(4) of the Constitution for holding an office of profit under the Crown, even though she had no conflict at the time of the July 2, 2016 poll. On Friday, Justice Stephen Gagler referred Ms. Hughes' confirmation to a full bench hearing next Wednesday after advising that she may be constitutionally ineligible to sit in the Senate. Fairfax Media can reveal the Nationals have received confidential advice from high-profile barrister Brett Walker SC about Ms. Hughes' eligibility about 10 days ago, and the likelihood of Ms. Nash being able to resume her seat if Ms. Hughes is disqualified by the High Court. Nationals contacted by Fairfax Media said they were hopeful the popular Ms. Nash could be returned to Parliament, though they acknowledged she faced an uphill battle. Former Australian Army General and Liberal candidate Jim Moeller is the next person on the New South Wales Senate ticket after Ms. Hughes and had been considered the front-runner to take her spot if the High Court rules she cannot take the seat. Colleagues of Mr. Moeller, however, said he was not planning to make way for Ms. Nash and would put his hand up for the Senate seat if it becomes available, setting up a potential clash between the coalition parties. But according to constitutional law professor George Williams, as Ms. Hughes was a valid candidate at the time of the July 2, 2016 election, if the High Court rules her out, then a casual vacancy would be created and that could be filled by Ms. Nash. In her, Ms. Hughes, case it would be that anyone could fill the vacancy from her party. It's even possible Ms. Hughes could fill her own casual vacancy, he said. The Constitution clearly states that a casual vacancy must be filled by a person from the same political party. Ms. Hughes, as a Liberal, and Ms. Nash, as a National, belong to different parties, which could be an impediment to the former deputy's return to Parliament via the casual vacancy. However, the Liberals and Nationals run on a joint Senate ticket in New South Wales, which could offer a lifeline to Ms. Nash, possibly with the assistance of a behind-the-scenes deal between party headquarters. On the question of whether Ms. Hughes would be found to have been not validly elected, Professor Williams said her situation was not promising. On the face of it, she is disqualified, as she held an office of profit between the time of nomination and her selection, he said. It does seem quite unfair. The question is whether the High Court will fashion an exception for her, and it is quite possible they will. The New South Wales Liberal Party has received its own legal advice, which senior party sources say left them confident Ms. Hughes was eligible because her appointment postdated the election.